Remedies here at the Wilson Center, and I'm delighted to welcome you to this event, Sexual Harassment at Work, Can Legal Remedies Change Employer Practices?, which is being co-sponsored with the Institute for Women's Policy Research. Our goal this afternoon is to offer you a first look at IWPR's important new report, Ending Sex and Race Discrimination in the Workplace, Legal Interventions That Push the Envelope, and copies of the report are available outside, and you're welcome to take one, and I suggest that you do if you're interested, because there aren't too many copies of this in existence, and it's an incredibly rich and valuable report with lots and lots of information in it. Most of us take for granted the idea that sexual harassment is illegal, but actually this was not always the case. And this report, as you'll hear about in detail shortly, allows us to step back and take a long look at the landmark period in U.S. women's history and in U.S. legal history when sexual harassment actually became a crime. And the report also, and the discussion will also help us look at what happened when that occurred and how that has spun out in legal history and practice. The period that I'm talking about was, of course, the 1960s and 70s when second wave feminism, the women's movement, emerged. The women's movement was one of the most visible and arguably one of the most successful of all the social movements that appeared during that period. And while it affected many aspects of American life, none of us would be standing here today if it were not for, or sitting here today if it were not for feminism, I think we could say. One of its most enduring legacies is surely the series of laws that Congress passed to address racial and sexual discrimination in the workplace and in education. These include the Equal Pay Act of 1963, Title VII of the Civil Rights Act of 1964, Title IX of the 1972 Amendments to the Higher Education Act, the one that brought us, among other things, the U.S. women's soccer team, the 1978 Pregnancy Discrimination Act, and the 1993 Family and Medical Leave Act. But as the women's movement and women workers and students everywhere soon discovered, passing laws is one thing, implementing them is another, and actually changing practices and behaviors in the workplace is something else again. The IWPR report examines how the laws played out in practice as thousands of workers, both women and members of racial minorities, sought relief. The processes, as you will soon hear, involve not just lawyers, courts, plaintiffs, and defendants, but also government agencies such as the Equal Employment Opportunities Commission, EEOC, and branches of the Department of Justice and the Department of Labor, as well as advocacy organizations such as the National Women's Law Center, the Southern Poverty Law Center, and the Coalition of Labor Union Women. This report, authored by Ariana Hegovich, Cynthia Deitch, and Evelyn Murphy, presents the results of an ambitious multi-year examination of over 500 lawsuits involving charges of sexual harassment, cases that ended in consent decrees, out-of-court settlements that were intended not just to redress specific wrongs, but also to change workplace practices. These cases cut across industries and occupational levels, ranging from financial services to agribusiness, and from professionals to low-wage workers, indicating that sexual harassment is not restricted to one group or one economic sector. Ending Race and Sexual Discrimination in the Workplace, the report that we're going to discuss, represents the kind of amalgamation of scholarship and public policy that the Wilson Center seeks to foster. As the nation's living memorial to President Woodrow Wilson, the Center supports dialogue between scholars and policymakers and showcases examples of research that have important implications for public policy. This report, which is based on scrupulous data collection and analysis, not only offers us keen insights into complex legal processes and their long-term impacts on workplaces and workers' experiences, but it also provides policymakers and advocates for women's equality with a basis for reforming and improving remedies for discrimination, and thus holds out great promise for the future. We're fortunate to have with us today two of the report's three authors, Ariana Hegovich and Cynthia Deitch, as well as a distinguished group of experts from the realms of government, law, and advocacy, who will help frame the report and spell out some of its practical as well as theoretical implications. In addition to those in the room, whom I'll introduce shortly, we're also going to be hearing from Monica Ramirez of the Southern Poverty Law Center, who will soon appear on that screen over there. She's busy she's actually in the middle of litigation, but she's managed to figure out a way to be with us for at least a short period in the second panel. So the presentations this afternoon, as you can see from the agenda, will be broken down into two panels. And before I introduce the first one, just a couple of technical notes. First of all, the report itself, as I said, there are copies of it available outside, but if there aren't any left, you can download it through the IWPR website. It's www.iwpr.org, and the URL is actually on your agenda, so you could just go to it that way. In the interest of saving a few trees, we've made only a limited number of copies of the PowerPoints that some of the panelists are going to be presenting. If you didn't get copies and you'd like to, please go to the United States Studies section of our new Wilson Center website, www.wilsoncenter.org, where the PowerPoints will be available for downloading after this session. Finally, our agenda will be as follows. We're going to have two panels. The first one will look at the landmark 1986 Meritor Savings Bank case, which established sexual harassment as a form of sex discrimination. And then the authors will provide an overview of the report. Our second panel will discuss different forms of sexual harassment and look at how they're being addressed not only through legal remedies, but also within organized labor. There'll be a brief break between the two panels, but don't go away. It's not really a coffee break. It's just to change out so that the speakers can change places. And then after our discussion, you're invited to join us all for a wine and cheese reception outside. So let me introduce the first panel. We have, first to speak will be Fatima Goss-Graves, who is Vice President for Education and Employment at the National Women's Law Center. I'm not going to go through her whole bio, you have it in front of you, but she's done a great deal to promote the rights of women and girls at school and engaged in many different strategies, including public education, legislative advocacy, and litigation. And she's also filed a number of briefs in the Supreme Court and federal courts of appeals. Our second speaker will be Ariana Hegovich, Cindy Deitch, who is one of the co-authors of the report. She's an associate professor of women's studies, sociology, and public policy at George Washington University and has done a great deal of research on the intersection of gender, race, and class in the labor market. And then our third speaker will be Ariana Hegovich, who is a study director at the Institute for Women's Policy Research, also one of the co-authors of this report. And she comes to us from Germany by way of England, and she's been here in this country for many years and done a lot of research at IWPR. And as I said to Ariana and Cindy just before the panel, this report is just incredibly impressive when you go through it. You see the enormous amount of work that's gone into it, the enormous amount of data that they've collected, and I think it's going to be an incredibly valuable resource for many years to come. So I turn the podium over to Fatima Goss-Graves. Sure. Thank you.
So thank you so much for having me today, and I'm really grateful for this invitation and to be among such an esteemed panel and talking about this really great report, which I, again, highly recommend that people pick up a copy, and if they don't get a copy, look on the website because it really, really is good. You know, as she said, at the National Women's Law Center, which was founded nearly 40 years ago and works to advance the opportunities for women and their families in all aspects of their lives. And in thinking about today's panel, I went back and tried to find the Meritor brief that the women's community filed, and the lead on that brief was then the Women's Legal Defense Fund, now the National Partnership for Women and Families. And it is sort of interesting to go back and look at the arguments that were being made on both sides. And that's another thing I encourage people to do. But it has been 25 years since the decision in Meritor, which is the case where the Supreme Court established that hostile environment sexual harassment is a form of sex discrimination actionable under Title VII. So that was 1986. And I went back and read the decision again to look at the standards and sort of think about them. And I was also looking back because I was just astounded by the facts in the case, and I thought it was worth sharing those details. And I thought it was worth sharing what the district court did. Oh. What the district court did in the case as well, in part because when you hear about the facts in this case, today there would be no question that this is something that is sex discrimination and that should be recognized as a violation of Title VII. So if you'll deal with me a little bit, I'm just going to deal with some of the facts in this and a couple of other cases. So Michelle Vinson was hired to work at Meritor Savings Bank by the vice president of the branch, Sidney Taylor, in 1974. And over the course of her employment there, she was promoted several times into different positions, and no one disputed that these promotions were all merit-based. And in 1978, she notified her employer that she was taking sick leave for an indefinite period of time, and she was terminated about 6 weeks later for excessive use of leave. She filed a Title VII case, and the case ultimately went to a bench trial. And the testimony that was offered at the case included things like that one night her boss, Taylor, invited her out to dinner, and during the meal suggested that they go to a hotel and have intercourse. And that initially she refused, but then fearing that she might lose her job, she agreed. And over the course of a 3-year period, they had intercourse over 40 times. And he would do things like, according to her testimony, fondle her in front of other coworkers, follow her into the bathroom and expose himself. At one point, or actually on a number of occasions, I think she testified that she had been raped by him and that this continued until she had a steady boyfriend. And so the district court in its decision said, you know, if there were an intimate or sexual relationship between the two of them, it was voluntary. And it had nothing to do with either the continued employment at the bank or her advancement or promotions, because she had continued to get promotions during the time that she was there. She therefore could not be a victim of sex discrimination while she was employed by the bank. It went on to say that the bank had a policy of discrimination, and so that it could not have been on notice that it could be subject to this type of action. So the Supreme Court, it went up to the Court of Appeals, and then the Supreme Court ultimately took the case, and Justice Rehnquist delivered the opinion of the court. And Meritor Savings Bank and its amici argued that when Congress passed Title VII, they were talking about compensation, terms, conditions, privileges of employment, and that those all meant things that had to do with tangible loss of an economic character, and that Vinson at no point alleged that there was any economic loss. So the court rejected that view, and relying on the text of the statute and on EEOC guidance and interpretations, it made clear, one, that Title VII wasn't limited to economic or tangible discrimination. It made clear that hostile environment type discrimination was every bit the sort of barrier to someone's work performance as other harassment that had been recognized on other grounds such as race. And it set out this standard that harassment must be sufficiently severe or pervasive to alter the conditions of a victim's employment. And it said, you know, a mere utterance is not going to be enough. But the facts as I've described them certainly wouldn't amount to a mere utterance. And then it went on to say that voluntariness is not a defense. So it was not enough for the employer to say she voluntarily engaged in sexual intercourse, but that the issue was whether whatever the sexual advances were unwelcome, and that was the main question for the court to consider. And then finally, in terms of liability, in some ways the court answered the question, but in some ways the court left it to be decided later on. So it declined to issue a definitive rule. It said the employer is not automatically liable for a supervisor's conduct in every circumstance, as one of the lower courts had said. But it also said that having a non-discrimination policy doesn't insulate you necessarily from a claim of discrimination. And then it said, we think that agency principles apply and that the courts will work it out, essentially. So it answered the big question, whether you can bring these types of cases at all, whether a hostile work environment was something that was actionable under Title VII. But it left a number of questions unanswered. And some of these the court ultimately answered. So, for example, several years later, in Harris versus Forklift Systems, another case with really egregious facts, the court made clear that the standard for a hostile work environment was severe or pervasive, but it doesn't have to lead to excessive psychological harm. In that case, the plaintiff had said that she was the target of repeated gender-based insults, things like you're a woman, what do you know? We need men in this job, things that were going on over and over, asking if she wanted to negotiate her raise at the Holiday Inn, things of that nature. And then finally she went to the president, who was the chief person engaging in the harassment, and said, this has to stop, complained to him, and he said, I was just joking, it'll stop, but it picked up again a few weeks later. The district court there found while the comments were offensive, they would not offend the reasonable woman, and they were not so severe as to really affect her psychological well-being. So again, the lower courts, as they tried to figure out what constitutes a hostile work environment, the Supreme Court stepped in again and said, you know, Title VII comes into play before someone has a nervous breakdown. And that a hostile environment, that not every hostile environment is going to seriously affect someone's psychological well-being. That may happen, and that may be a factor to consider, but the courts must consider the total factors. They consider the frequency, the severity, whether it was physically threatening, whether it was humiliating, how or whether it interfered with an employee's performance, a whole range of things. So again, the court stepped in, built off of what happened in Meritor, and clarified things. The court had to step in again and clarify things in OnCal versus Sundowner Offshore Services. And there the question was, what happens when there's same-sex harassment? The courts had differed here. Some of the courts had said same-sex harassment is never a violation of Title VII. Other courts said it can be. And then some courts said, you know, had sort of an interesting test of, well, if it's motivated by sexual desire, then it can be. So the court stepped in again and said, nothing in Title VII precludes same-sex harassment. Applied Meritor and Harris and said, you know, like other cases, it's important to consider the circumstances, the situation, the context, and that's what it should look like. And the last big thing that I'm going to just mention briefly is that the big question that Meritor didn't answer was around liability. So in Burlington Industries versus Ellerth and in Farragher versus City of Boca Raton, cases that were decided on the same day, the court looked at, well, what happens if you have a hostile work environment where the plaintiff didn't suffer any adverse job consequences? So they weren't terminated, they weren't, you know, there wasn't a reduction in pay, something of that nature. What happens then? And the court had, again, recognized that hostile work environment was an actionable claim. But it held that an employer can be vicariously liable. So the employer can be liable for the conduct of a supervisor, but it allowed employers to raise an affirmative defense in some cases. And the employers could show essentially that they had taken all reasonable care, but the employee failed to take advantage of all that they have offered. So in this time, the court has really clarified things. Meritor is still good law, which I think in these times we have to celebrate and sort of take a step back, but also look how far we've gone, because the facts of Meritor, the facts of Harris now, no one would question whether there's sexual harassment. And I just wanted to note that some questions still remain about what the court needs to take care of, or what the court may or may not be taking care of soon. And one question that the Fourth Circuit recently weighed on, and the 11th Circuit as well, is whether the harassment has to actually be directed at the individual who's complaining. So in a recent Fourth Circuit case, a woman, was repeatedly subjected to an environment where there's lots of sexual conversations. Derogatory names for women were the norm. Photos and pictures of women who were naked and scantily clad were constantly held, put up in the workshop where she worked. But the employer argued that they never actually said anything to her. It just was in the air where she worked, and that it had to actually be directed at you. And the Fourth Circuit said that the conduct didn't actually have to be directed at you. So that is another question that I think that we're going to see percolate up and see how Meritor stands up.
Great. Cindy. Yeah. Great. That's great.
I'm going to start by giving a little more overview of the IWPR report that Sonia actually very definitively and graciously introduced. The report, as you already know, was a collaboration of IWPR with the Wage Project in Boston. It was funded by the Ford Foundation. We examined over 500 sex and/or race discrimination consent decrees. We looked in depth at a small number of cases that you'll hear about some of them today. We did interviews with over 40 attorneys and others who negotiate, monitor, or implement employment discrimination consent decrees. And also, I want to clarify and point out that the IWPR report is not only about sexual harassment, it's about half about sexual harassment. However, the majority of the sex discrimination cases we looked at, and of all sex discrimination cases these days, as well as 2 of our 4 in-depth studies, are on sexual harassment lawsuits. And here's a brief chart showing our 4 in-depth studies that each are the focal point of a chapter in the report. I'm going to talk about the Neal v. DC Department of Corrections case. The big question that frames our report for both sexual harassment and other forms of race and sex discrimination in the workplace was, do consent decrees as a resolution of employment discrimination lawsuits lead to meaningful change that reduces inequality in the workplace? The short answer is sometimes, occasionally. And I'm going to talk about 1 or more of those occasions, and then Ariane will talk more about what happens the rest of the time. Okay, I'm now going to turn to one of our case studies, the Neal v. DC Department of Corrections, which is one of the few ever class action sexual harassment lawsuits. And I'm going to, wait, was there a slide missing here? Yes, okay. Before going on, I want to just briefly explain what consent decrees are, because not everybody is clear on that, and we certainly weren't when we started this. They are the formal written settlement agreements negotiated by the parties to the lawsuit and enforced by the court. And unlike private confidential settlements, they're public documents, which was very key because otherwise we wouldn't have been able to study them. They include what's called injunctive relief. So as well as the relief or monetary awards to the individual plaintiffs, they require employers to agree to changes in the workplace. And even though the employer doesn't have to admit doing anything wrong, because this didn't go to trial as a settlement, but they agree to make a variety of changes. Sometimes are very general, and sometimes are very long, detailed, and specific. The other key thing, and that's why we were interested, because we wanted to see what do they actually require, and is it likely to be effective? I also want to point out that very few sexual harassment charges actually ever reach the litigation stage, but when they do, settlement is more likely than going to trial, so that's another reason why studying these settlements was worthwhile, we believe. Okay, so now I want to turn and sort of tell you a bit about the story of the Neal lawsuit against the DC Department of Corrections. Well, one of the things that was really interesting about this, and particularly appropriate for our panel today, is that the DC Department of Corrections has a long history of sexual harassment lawsuits. And in fact, back in the 1970s, a young African-American woman who came out of the civil rights movement, her name was Sandra Bundy, and she experienced what we now call hostile environment harassment. And she filed a lawsuit, which is in all the books and important as Bundy v. Jackson, which was one of a few appellate-level decisions that led to the Vincent case, but it came before it. And in fact, the Supreme Court in Vincent refers to the Bundy decision on the issue of hostile environment harassment. Okay, but while Bundy was making history in the law books and in our country in terms of sexual harassment law and policy, very little changed back in the Department of Corrections, showing us that an important lawsuit legally and historically doesn't always affect people's lives on the ground. The Bundy lawsuit resulted in a permanent court-ordered injunction against sexual harassment at the Department of Corrections, and yearly sexual harassment training or anti-sexual harassment training, and what appeared at the time to be a very detailed, comprehensive policy that was quite advanced for its time. However, what our research shows is that just having a policy on the books, if it's not implemented, not taken seriously, isn't enough. And this one was not implemented and was not taken seriously. And the subsequent Neal lawsuit and many other lawsuits against the same department showed that women were routinely dissuaded from filing complaints. The complaints were lost or ignored. If they were investigated, the investigation was sloppy, using inappropriate criteria. Sometimes the investigator of one complaint would be a friend of the harasser or somebody who was charged with previous harassment complaints. And retaliation against women who refused advances, as well as women and men who tried to help them, who complained, the retaliation was rampant. And I'm going to just give you a couple grisly examples because I think they illustrate both this idea of hostile environment, and we often hear like complaints of things like lewd behavior and think, well, or people say, well, are these women just too uptight or something? And so these come out of the lawsuit. When a male coworker exposed himself to a woman and came toward her, she threw a chair at him, and another woman in the same situation set the guy's pubic hair on fire. When they complained, the women were reprimanded for unprofessional behavior and not following policy and lodging a complaint. And another example, one of the 8 named plaintiffs in the Neal class action suit, her story was, or one of her stories was that one day her supervisor, who was like taking an unofficial lunch break, eating chicken, started feigning oral sex on her and making sucking noises and getting everybody to sort of make fun of her. When she complained, he just, when there was an internal charge, he just said he didn't remember, and so it was dismissed because he was a supervisor. It was her word against his. But meanwhile, everywhere she went, men were making these sucking noises at her. Not only her coworkers, but also the inmates she was supposedly, in charge of. And so this, quote, lewd behavior was a constant harassment, hostile environment, and prevented her from effectively doing her job, and the internal policy dismissed it. So those are just a couple of the examples. Moving back in time to the 1970s, at the same time of the Vincent lawsuit and Sandra Bundy's lawsuit, another young African-American woman, Bessie Neal, started working as a rehabilitation counselor at the DC Department of Corrections, and she was subjected to constant harassment. In one case, physical and verbal. In one case, a coworker squeezed her breast so hard she went home bruised, and when she complained, his excuse was, oh, he thought he was squeezing an orange, and so he was not penalized in any way. And she filed complaint after complaint, literally going back from the 1970s through the 1990s for decades. Some of she was denied promotions. Men she trained were promoted above her. At one point, they moved her desk in winter in front of an open window in attempts to drive her out, but she persisted. And some of her complaints ended up at the offices of the Washington Lawyers Committee on Civil Rights, an organization that, going back to the 70s, was involved in some of the early sexual harassment lawsuits. Okay, so going forward 15 or 20 years, in 1992, Teresa Washington arrived at the records office of the Department of Corrections, eager to try to advance in her job. The head of the department made it clear that the only way she could get the training she needed to be able to advance was to do the training with him at home, at his home in the evening. She filed, she lodged a complaint with a local advocacy group who, Holly Fechner, a member of that group, a volunteer attorney for the group, gathered together information from Teresa Washington and other women, brought it to Joe Sellers at the Washington Lawyers Committee, who put it together with the other cases he had. Joe Sellers also and Christine Weber, who worked with him on that cases, are the attorneys who argued the recent Dukes v. Walmart case. And so that was the Neal lawsuit. It actually went to court, to a jury trial in 1995, was awarded the largest sexual harassment award ever at that time, overturned in a technicality, and then eventually settled before the next trial, and there was a consent decree starting in 2002. And that is the focus of what I want to talk about next. That consent decree established an office of a special inspector who had the power to investigate, set up sexual harassment training, hire other people, and issue punishments short of total dismissal. And we, from our research, concluded that this was very effective. The consent decree also mandated a 24-hour hotline, at least to be tried, an employee ombudsman, an employee advisory committee, and a variety of other things. And basically, to move quickly ahead, we also were curious if that was just a single unusual effective case. And by effective, I mean only during the 3 years of the consent decree, because a lot of these things fell off afterward. Okay. But we also looked at a couple landmark big pattern and practice EEOC sexual harassment cases. The Mitsubishi case, which many people know about, and the one we looked at more closely was against the Dial Soap Corporation. And those were also, they had many similar features and some different ones. Some of the key similarities were independent external monitors, a multiple avenue complaint procedure, timely confidential complaint procedures, investigation by competent, trained, objective investigators, and most important for all of this, through the lawsuits and the awards that were part of the settlement, adequate resources to actually carry out these things. They also had real consequences for harassers, and try to have protections of complainants against retaliation, though it's not clear, like at the DOC, how successful that was. The DC's DOC one also tried to have in the consent decree a mechanism for continuing after the consent decree expired, and like I said, that was less successful. And do I have like a couple seconds left? Sure. Okay. Because there are 2 points I want to make, a little out of sync here, but 2 decades of sexual harassment research by social scientists, not us, has shown that from anonymous, confidential self-report in surveys in a whole variety of different workplaces, that the things that seem to matter most in terms of higher rates of self-reported sexual harassment are employees who don't think they'll be treated seriously, they don't believe the harassers will be punished, and they fear their careers will suffer. And we feel that the reason the Dial, Mitsubishi, and Neal consent decrees were effective is they managed to create change the environments so that these 3 things were lessened, even if not perfectly. The one other thing that I wanted to end on is that I think it is not simply a coincidence that in all three of these cases, they were unionized workforces. Because even though the unions didn't prevent the sexual harassment, they were at least workforces where the grievance procedures already existed, not perfect ones and ones that weren't adequate for sexual harassment, but you weren't starting from scratch like we'll hear about immigrant women in places where there are no rights and no protections. And I also think that unionized workforces, and we'll hear more from Clue on this, provide an environment where there's a mechanism where people expect to fight for their rights and may be more likely to mobilize, although that doesn't always happen. At the DC-DOC cases, there were male and female shop stewards who helped women file harassment complaints, and it actually was part of their union contract that they should be protected against harassment, which didn't really help, but and that these shop stewards were also harassed, not sexually, but they were retaliated against. And so I wanted to just briefly raise the union role, which we'll hear more of as we go on.
Thanks, Cindy. I'm sorry to rush everybody along, but we have to be ready when Monica Ramirez appears on the screen, so that's why I'm trying to keep everybody to time.
Thank you very much, Fatima and Cindy, for kind of doing those great presentations first. I'm going to step back a little bit and talk more about the, if you like, the average cases in our database. The cases Cindy just mentioned were selected almost specifically because we were hoping they had good practice in them, that they might have lessons for more general litigation or approaches to discrimination in the workplace, in line with the really fantastic stipulation under Title VII that remedies should not just provide relief to whoever suffered discrimination, but should improve the workplace for everybody working with those people and coming afterwards. I should probably say at this stage that neither Cindy and I are lawyers, which probably was good and bad, bad for us because we kept saying, what's this? And probably the people who talked to us were a little mystified sometimes at our questions. But on the other hand, my background is in human resource management, Cindy's in social sciences, so we probably focus more on how organizations change and what makes them change rather than what's right or wrong and why they should change. And that kind of process orientation probably informed the way we looked at cases. Now, to start by stepping back a little and putting our database into the general legal environment on sexual harassment, we looked at cases that were settled during the period from 2000 to 2008. On average, during that period, although cases typically take a couple of years before they're settled, the EOC received something like close to 14,000 charges of sexual harassment each year. And what is interesting, and I'm not quite sure why, others of you might have a view, and perhaps there's real positive change. During the last decade or so, there has been a steady decline in charges on sexual harassment to the EOC, and also a decline in the proportion of charges who are concerned with sexual harassment. So maybe we're getting to a stage where the general environment is getting better, but still there are certainly bad cases and hardcore cases going on. Not all charges are found by the EOC to have reasonable course, and of all the court cases that are found to have reasonable course, only a small number end up in legal settlements that include organizational relief, that include mandates on employers to have new policies or change disciplinary procedures or whatever. So annually, there are only about 100 to 115 consent decrees on sexual harassment. This is what is in our database that we looked at. We've got about 500 cases, and of those, about a third and slightly over half of all sex discrimination cases directly look at sexual harassment. I'm saying this because all these cases are in the database, and you can search the database if you're trying to find the legal document for any particular case, which often looks at the remedies, but also might give you some ideas of the circumstances where people worked. What is interesting, yesterday, and I decided I need to be more positive in what I say today. Yesterday I had a conversation with a French journalist, and because of the World Bank directive case, in France, there's a lot of concern over that, and we forget in a way how far we've come here, that sexual harassment is accepted, by most people as sex discrimination, and we can litigate it in the courts. We're far removed from that in France. But, she asked, is it mainly something that concerns small employers or, the worst employers? And we found at least the EOC cases go across the board and across types of workers. But they are especially prone in the service sector. And I don't know whether you came across the recent Novartis case was an actual large class action case which was settled in a jury trial, so atypical. And it was 250 million penalty or awards on the company, the largest ever. Sexual harassment wasn't an explicit part of class class action in that, but if you looked at it, the women representatives faced a lot of harassment, but they had to go into doctors' offices. Doctors assumed all kinds of things, and that was part of the kind of sales strategy of the company. You send a woman, you sell it, and if you complain, well, if it's a big client, pull yourself together and move on. Those type of things, up down to, the cases that also Monica will talk about in greater detail, women who are in the lowest paid jobs and are least able to defend themselves because they might be undocumented migrant workers, with really terrible cases of harassment, including rape and threats to your family, and really, criminally bad examples. I also was particularly interested, I work on wage discrimination. We always get this comment, it's choice. Women don't want to work in the police department. They don't want to be firefighters. They don't want to work on oil rigs or in manufacturing. And you look at these harassment cases, women are kept out by sexual harassment. And they choose not to go into certain environments because they think, what's the bother? I'd rather have a slightly better life than, fight there where it doesn't seem to be very successful. Anyway, back to our database. Just to say, we looked at about a slightly under a quarter of all EEOC cases, and we biased our sample to those where there were more plaintiffs or where there were something like class action. So we probably underestimate slower cases. For the Department of Justice, the DOJ, we looked at all cases we could find. We think that 45 is a pretty complete list of all cases, and 15 of those are, or a third, are sexual harassment. And we also included all publicly available private class action cases. If you look at this, you can already see, you know, only 17% of private class action cases, which typically are highest profile and get the biggest rewards and remedies, deal with sexual harassment, compared to about a third of the cases taken by the EEOC or the Department of Justice. And you can also see that both the EEOC and the Department of Justice tend to focus on smaller cases. Now, in terms of the as Cindy described kind of from the Department of Justice, often sexual harassment, I mean, it only gets to court if you complain. And so often it's linked to retaliation. You try to complain, and then you were hit with this, that, and the other. Several of those include constructive dismissal, where you leave your job because you can't stand it anymore, or termination. But what struck us that compared to privately litigated cases, a lot of the other ones are only sexual harassment or retaliation termination. They do not include the other parts of employment, whether you get promoted, whether you get trained, whether you get assignments which lead you to further opportunities, whether it's part of hiring. So it has a kind of narrow focus on sexual harassment and the immediate consequences, and doesn't really seem to take up the kind of broader, you know, claim, or the revolutionary part of the Supreme Court and Title VII to say this is sex discrimination in employment. It goes beyond getting rid of the harassment itself, which is important, but you also need to have an opportunity to equally advance. Now, looking at the remedies, slightly switching emphasis, on the left there are the remedies which, you know, we looked at, which are typically mandated. Employers are mandated to have harassment or diversity training. They might be mandated to have new grievance procedures, a whole range of issues. But as you can see, the kind of standard are 4 type of policies and or approaches, all very formality focused: to train, provide training, distribute or create and revise the policy, and to have a new grievance procedures. And those type of approaches, remedies, are fairly directly informed by one of the cases that Fatima mentioned, the Allard and Farragher Supreme Court, which seemed to kind of limit employers' liability if they have policies, if they can show that they train people, and if they have a grievance procedure. However, as Cindy also showed, policies on their own do very little. And unless they're followed through with other employment practices, you know, actually most of the companies who end up in courts do have policies by now. So having a policy and a grievance procedure in itself doesn't seem to do terribly much. What was striking is that not more companies, or not more consent decrees for us in the legal negotiation, included explicit mandates on supervisors to take active charge of their work areas. Clearly, supervisors, if they harass themselves, are liable. But they also should have a responsibility to make a decent working environment. And that's not specified in a lot of decrees, whereas there's some very good examples, both from human resource management best practice and from the large class action cases. And very few of them explicitly have policies which would allow you to check, A, that there is no retaliation, and B, that there is advancement around transparency in hiring, termination, job assignments, and so on. I wanted to highlight a couple of cases which kind of go again, have more innovative or extensive policies. And these happen to come from litigation in agribusinesses. Some of the worst cases we come across are against migrant and immigrant workers working in the agribusinesses. And the EEOC in California has done a lot to advance practice and to be strategic in the way they select cases. The first big class action was one against Tanimura and Antle, who are multinational lettuce growing company, and it involved sexual, quid pro quo. You have sex with me if you want your job by supervisor. It involved rape, and it involved retaliation also against the man who stood up against the supervisor. But what was interesting is that the case itself didn't just say you have to have a policy. It included extensive media outreach to make sure that people knew that they had rights. It included a lot of cooperations and came out of cooperations with community groups. And it had a kind of, a detailed schedule of actions and included supervisory responsibility. And it was distributed, everything was done in Spanish and English. The other case, and there are others like this, against a vineyard in California, I think is even more interesting because it's a sexual harassment case, including rape, very bad case. But it, both in the charging and in the development of policies that the employer had to include, it's comprehensive. It includes hiring targets. It includes policies designed to give women training so that they could move into higher earning jobs, which were involved pruning of plants and whatever. It went down to detail, to enough detail to say it's not enough that you have training. The training has to be in a public space or in a space where the women feel free from harassment, because the trainers would be guys, given that there were no women who had those policies. And so it was a really rounded case, which kind of took seriously the connection between sexual harassment and creating equal employment opportunities. Okay, conclusions or questions for further discussion. The first issue that concerned, does litigation stop sexual harassment? It's very hard to figure that out, save, short of new cases coming forward. It's partly because it's very hard to measure whether there is sexual harassment or not, because if nobody complains, it might be because there is no harassment, or it might be because people are afraid to complain or don't know how. Same, if there is a lot of complaints, it might be a positive change period because people at last feel confident that there is something they can do. So we try to push the idea perhaps of having anonymous employee surveys also, which we thought might work, as one way of monitoring in a large law case. And it was interesting that we got a lot of kickback against that also in other areas, because employers are so scared of litigation in this field that there is huge opposition to any formal measuring, because they think they might get more claims. So I think it's an area to look at. How can we, through outside groups, or what are ways of getting that information, even to employers who are willing to do something, and with and not relying on this kind of narrow focus on just having a new policy and just kind of dealing with the individual, or counting really how long it takes to deal with a complaint. The second issue is that, as I said, it's really quite amazing that coming from Europe, looking, at all the other things going on, but the Supreme Court recognized sexual harassment is discrimination. Is this reflected in the remedies? not so much. Really, the remedies that are negotiated tend to focus more on stopping sexual harassment rather than on stopping sexual harassment and ensuring equal opportunity. So for us, the question is it possible to have, if a company ends up in front of court, not a lot of them do with the EOC or with the Department of Justice or whatever, then shouldn't we just screen all their employment practices and insist that as a minimum they have transparent recruitment and promotion policies? Can we push this more so that actually it deals with the whole issue of employment? And finally, what was striking is because it is so hard to get class action certification in privately litigated sex discrimination cases or race discrimination cases, really the EOC is the main enforcer of sexual harassment law. And we found that, the EOC does not have a lot of resources. And we've talked to some investigators who said, well, we go to the fields. We know that physical violence or rape has taken place, and we can't get the police to take this seriously. There might be good reasons for the police to stay out of this, but we feel that somehow, a lot of burden of this is on the shoulders of the EOC, and that maybe that should be more widely shared. And finally, link between domestic violence and work than there is on sexual harassment. That almost we feel, maybe people feel that isn't such a big issue anymore, or because it has passed to the courts, and the courts maybe are more effective in getting higher remedies than individual litigation might, or for whatever reason. But it seems to me that there is an absence of the women's movement, or a greater absence than I had anticipated. Anyway, thanks a lot.
Thanks, Ariana. I think because we know that Monica Ramirez is very pressed for time, can we get her now? Yeah. We'll just move right to her presentation and questions specifically aimed to her. And then after the second panel, we'll come back and there'll be time for general discussion and Q&A. I know you've probably have many questions and comments on these wonderful presentations that we've just heard, but in the interest of getting Monica in here, we'll move right to her if we can. AV folks. Okay, here you are. Hi, Monica. Can you hear me?
Hi, I can hear you.
Oh, great. Thank you very much for being with us. Let me just briefly introduce you. This is Monica Ramirez, who is with the Southern Poverty Law Center, where she directs something called the Esperanza, the Immigrant Women's Legal Initiative. And this project is dedicated to eradicating sexual violence and gender discrimination against farm worker and low-wage immigrant women. And I won't take time to introduce you any further. Everybody here has your bio, and I just want you to have as much time as possible. So welcome, Monica.
Great. Thank you so much for inviting me to be part of this important celebration and discussion. I'm sorry that I can't be there in person, and I'm sorry that I don't have a lot of time today to participate in this whole presentation. The area of which we practice here at the Southern Poverty Law Center is very much focused on the interests of immigrant women and farm worker women in the United States. And I think that as we look at the issue of sexual harassment and where the law has evolved, how the law has evolved, and whether or not we've made strides in the past 25 years since the Meritor decision came down, I think that the cases of the women who we represent are important cases to hear about and to learn about, because I think certainly while strides have been made, there's still quite a work left to be done. I want to give you some context in terms of who the women are that we represent. The low-wage women that we represent work in a variety of industries, agriculture, of course, being one of them, but we've represented women working in hotels, restaurants, factories. Some workers are engaged in domestic work, and certainly there are many different places in which these women are working, like poultry plants and meat processing plants. And what we found in our work representing the women is that their work is characterized by low pay pretty dangerous conditions, very few benefits, very few opportunities for advancement and or for training. And what we also have found through our work is that the women who are doing these jobs are being denied a host of protections. They're not, as I said, they're not being paid adequately. They're victims of wage exploitation. But I think that most startling to us through our work has been realizing that across the board, women who are employed in agriculture, low-wage immigrant women employed in agriculture, and some of these other low-wage industries are being victimized by way of sexual violence in the workplace. And I just wanted to share with you a few of the statistics that we have at our disposal related to the victimization of low-wage immigrant women and farm worker women. As you can imagine, there is not a lot of data out there to really help us fully understand the extent of the problem. But this past in November of 2010, we published a report called Injustice on Our Plates. And I think the link is being made available to those of you who are at the presentation, and you can certainly get it from us afterward. But in that report, we interviewed 150 women in 6 different states in the United States. And of the 150 women who we interviewed, 100% of them said that sexual harassment was a major workplace problem. And the sexual harassment that they were experiencing ranged from inappropriate sexual comments and touching to sexual assault and rape at work at the hands of company owners, supervisors, and co-workers. And the women talked to us about having since migrated to the United States from different countries, Mexico, El Salvador, Honduras, and others. They talked to us about experiencing sexual harassment not at just one job site, but having come to the U.S., taken up employment in one place, experiencing sexual harassment, going to another place, experiencing sexual harassment. So the issue wasn't isolated to a particular sector of the agricultural industry or to a particular industry in which low-wage women were working. It seemed to be a widespread problem. And the question that we're focusing on today is, can legal remedies really change things, change the behavior of employers? And having litigated cases on behalf of farm worker women and other low-wage immigrant women, I mean, certainly our goal is to eradicate the sexual violence against them and to determine ways that when we are seeking recovery for these women and justice for these women, that we are also ensuring that the practices at the work sites change so that no other women experience the kind of violence that these women have experienced. And I'll tell you that the women who I represented over the past just almost 8 years, they very much, the only remedy that they really seek when they're coming into these cases is that they don't want it to happen to someone else, because oftentimes their lives have been destroyed because they've suffered extreme trauma, sometimes physical violence that's resulted in lasting injury, and they often talk to us about the fear that they have, fear of going to work, fear of being sexually harassed in other places, and they don't want other women to be afraid as they're afraid, or to be harmed as they've been harmed. And so that's the principal remedy. And so when we think about whether or not litigation can in fact change employers' behavior, I think that we have to focus on what is it, if we're looking at Title VII as a remedial statute, meaning our number one goal should be prevention. How do we prevent sexual harassment, as opposed to how do we get justice for those who've experienced it? Certainly lawyers who are litigating these cases are seeking justice for those who've experienced any type of discrimination that would be actionable under Title VII or any state anti-discrimination laws. But as an anti-violence activist and expert, I think that one of our primary goals is prevention. And is litigation a tool that can be used to prevent sexual violence in the workplace? I think that's a question that we have to think about and address. And the reality, I think, is sexual violence will not be eradicated until people make the decision to stop committing sexual violence. Can we change employers' behaviors so that we ensure that they are creating policies that employees will have access to so that they will know how to complain if they're experiencing sexual harassment? Or can we have employers implement practices that will encourage safe workspace or encourage different employees to complain using different mechanisms? Like in the case of immigrant workers, are we going to encourage employers to engage companies like Language Line and other interpretation services so that people will feel comfortable reporting in their own language? What are the non-economic remedies that we can seek that would force employers to improve their workspace so that we are focusing on prevention of sexual violence as opposed to getting relief for people afterward? Having litigated the cases on behalf of women, I think that litigation is definitely a mechanism by which we can get employers to change their practices. I think one of the number one problems that we see in the agricultural community, where we know that 90% of women in one study in California have said that workplace sexual violence is a major problem for them, and 80% in a recent study in California said that sexual harassment was a major problem for farm workers. When we have statistics like those, which are alarming statistics, but they're telling us that nearly every woman working in this industry is experiencing this kind of violence, you have to wonder, why is it happening? And the reason it's happening is because the cases aren't being litigated. And I know that Ariane spoke of a case that was litigated in California, the Harris Farms case. That case is extremely important because it does send a message to employers that if you do permit sexual harassment in your workplace, there will be consequences. And the price tag for permitting sexual harassment to occur or for not taking appropriate measures to remedy it once the employers become aware of it, there will be a hefty price to pay. But the reality, I think, when we look at Title VII and whether or not it is a sufficient, whether the current remedies available under Title VII are sufficient to really force employers to change the way that they're practicing business, I think that we have the first obstacle that we have to deal with is the fact that there are caps that are in place that limit the amount of damages that someone could get if they're a victim of discrimination. And we know that the caps are determined based on the number of employees who are working in a particular establishment. And so I think that the caps are problematic because often for low-wage immigrant women and farm worker women, they're working with smaller companies who would have a lower cap, who might not be scared off by the price tag that might come along with having to litigate a case like one of these. I think the other reason the caps are problematic from a victim perspective is how do you measure what one person suffering is worth who's experienced rape at work based on the number of people that they work with. Certainly a woman who's been raped at work's trauma is not amplified because she works with 300 people as opposed to someone who's been raped in a place where they only have 100 employees. And so I think the caps are problematic, and I think that when I think about whether or not we can use litigation to change employer practices, I think that we need to deal with the caps and getting the caps changed or having them lifted so that we're not bound by that, so that we can let juries and judges make a determination about what someone should receive when they've been victimized in this way. I think the other thing that we have to think about specifically when we're talking about immigrant women who've been victims of workplace sexual harassment is that a lot of these women do not speak English. A lot of them do not have a lot of information about their rights. They don't understand our legal system. They don't know how to file a charge of discrimination, or sometimes they don't know how to find an attorney that might help them. And so I think that, yes, we need to bring the cases, but we're not going to be able to bring the cases until we get the information into the hands of the people who need to be served about the fact that they have rights and the fact that there have been litigants who've brought these cases who have been able to get some measure of justice. This brings me to the next problem I see with the litigation that's currently being done, or with litigation related to these types of cases, and that is that I think that often, particularly when we are litigating cases where the EEOC is not involved, it's pretty standard practice to accept a confidentiality agreement as a part of the settlement agreement. The EEOC does not permit, and I'm sure this was probably addressed earlier, the EEOC does not permit confidentiality agreements. It is public information when a case has been settled by the EEOC, because the EEOC believes that that's part of their mission, to educate people about the kinds of cases they're litigating. But when you have a litigant whose case is not being litigated by the EEOC, then frequently, almost always, companies want confidentiality. And what that means is that, yes, we might bring an investigation of harassment against a particular employer, and we might get relief, both monetary and non-monetary relief for the victim that is significant. But at the end of the process, the litigant is put in a situation where they have to decide if they want to settle the case and not go forward with litigation. Are they going to be willing to sign a confidentiality agreement? And more often than not, people do sign confidentiality agreements because they want to put this behind them. The sexual harassment they've experienced has been painful enough. Their lives have been wrapped up in these investigations and in the litigation, sometimes for years, and they want to move on. And so signing a confidentiality agreement that will permit them to move on is something that they are willing to do. But what does that mean for changing employer practices? Well, if we can't talk about the kinds of agreements that we're entering into with some of these companies where sexual harassment is taking place, then we can't use those cases to educate other employers about the kinds of consequences that they will face if they don't stop the harassment from taking place at their establishment. So that's another problem. I think that the last problem that I want to address on behalf of immigrant women and farm worker women is that we are currently in our country living through a time of great hostility towards immigrants. We are faced with a situation in which the environment is so hostile for immigrant women that employers are using immigration status as a stick against them. And it's not just the undocumented women who certainly have relief under the federal law of our country. We're talking about women who have permanent residency, sometimes U.S. citizens who are living in mixed status families, so their spouses might not have status, or maybe their children don't have status, or people in their social network don't have status. And what employers are doing today to these women is that they are threatening them with immigration enforcement and or enforcement by other law enforcement agencies. They're making up lies about crimes that they allegedly committed to have them arrested. These are things that are happening. I've worked on cases where this has happened, and I can tell you that the threat of immigration enforcement and or enforcement by another law enforcement agency is certainly enough to chill one's willingness to come forward. And I think that right now, in the climate that we're living through with this situation of immigration in our country, I think employers do not believe that immigrant workers are going to bring these kinds of lawsuits against them. They're not afraid that there will be consequences because they don't think that people will take action. And I think that when 90% of a population, or in the case of our report, where 100% of the women reported they're experiencing sexual harassment, with very few of them having taken any kind of action, I think that unfortunately, in some ways, the employers are right. The women are experiencing harassment, sexual assault, and rape at alarming numbers, and they're not making their reports because they're afraid. And so, can litigation change employer practices? Yes, but employers have to fear that workers will in fact bring litigation against them. And so at the Southern Poverty Law Center, what we are doing is we are bringing litigation on behalf of the women who experience this problem. And we're engaged in community education, and we're engaged in educating some of our political leaders about this problem because, in our opinion, immigrant women and farm worker women employed in the United States are currently faced with an epidemic that we are trying desperately to help stop. And I think that having an opportunity to be on this panel is significant for us because we know that while I'm not physically present there, we know being able to share this message with you will certainly bring us a step or two closer in getting justice for these women. So thank you so much for the opportunity to speak to some of these issues. I'm available and willing to take some questions. I know there are lots of other wonderful speakers there with you, so I don't want to go on too much longer, but I'm happy to take a few questions if you have some.
Sure. Thank you so much, Monica. This is really Terrific. So let's take a few questions, as long as we can have Monica with us. Questions, comments? Yes, please. Yeah. Wait for the mic. Yeah. And please identify yourself. Yeah. Okay. It'll be there. Just wait a minute.
I'm Mark Gruenberg from Press Associates Union News Service, and one of the panelists before you was attempting to make the comparison, which I'd like you to make also, saying it's trying to compare the frequency and the not hostility, but the frequency and the awfulness of harassment directed against minority and particularly minority immigrant women, as opposed to the frequency and awfulness of the harassment directed against other women. From your litigation, can you make any comparisons?
Well, I think that, thank you, Mark, for the question. And I must say to all of you, you can see me, but I can't see you. So it's a little bit strange being over here on this end of the computer. So having said that, it's really hard to know how many women are experiencing sexual harassment, because while there have been a few studies done, there are a lot of people who are not making any kind of report, they're not filing charges of discrimination, and they're not engaging in litigation. If the statistics that we have, which are at this point, 90% of the women engaged in this particular study in California, 80% of women engaged in a 2010 study, and then our recent report, which included women from 6 different states, 100%. I would venture to say that the incidence of sexual harassment against immigrant women, specifically low-wage immigrant women and farm worker women, is higher than in other industries. That means, that if we have, I don't actually have the statistic in front of me to be able to share it with you, but I would be quite shocked to believe that the average working person, average working woman who's non-immigrant, non-farm worker, is experiencing sexual harassment at the same rate. And I can't give you any specifics, I can't give you a direct comparison because I just don't have that data in front of me. But again, I think that when you have such large numbers reporting that they're being harassed over and over again, and your other part of the question was, what is the egregiousness of the harassment? And based on our work, number one, when we've engaged in litigation, we know that it's not just one woman at the work site who's been experiencing the problem. We might only be able to get one woman to come forward, but it's typically many women who are experiencing the problem, which is why we try to do classes. And I know Ariane talked about why those are difficult, but certainly that's one of the goals, is to try to get relief for everyone. And then, so I think that in particular work sites where we've litigated cases, it's more than one woman, and the egregiousness, it really does range from the touching and groping, inappropriate comments. We're seeing more of what we're calling sexting, where workers are taking pictures of women's bodies and then texting the pictures to other people. But in the farm worker context, we're seeing more cases of rape in the fields and sexual assault. So I think that the cases that we litigate tend to be the very egregious situations where people are being attacked at work, and sadly, they're being attacked more than one time. So it's not like they're being forced to have sex or being raped once. The women, because they feel like they have no options, stay in those jobs and are being raped repeatedly in some cases.
Cindy and Ariana, do you have any statistics? And does anyone else have any? Yeah.
Hi, my name is Carly Chenault. I'm an intern with IWPR. My question is whether or not your agency does a lot of work with immigrant domestic workers, and what type of remedies are available for these women whose employers obviously don't have enough employees to meet EEOC's threshold.
Sure, that's a great question, and I think that's also that also sort of speaks to the question as to whether or not these kinds of challenges have an effect of changing employers' practices. Because, for example, in the Southeast, which is where we work, many employers are not covered by Title VII. They're smaller employers, they don't have 15 employees or more, and in the South, many of the states don't have state anti-discrimination provisions, which would allow people with fewer than 15 employees to bring any kind of action. And so certainly that is not helpful for workers who are experiencing sexual harassment in smaller settings like domestic workers. I have not personally litigated a case of sexual harassment on behalf of domestic workers. However, in the cases that we have worked on, not just on behalf of domestic workers, but other workers also have other types of remedies available to them, other civil remedies available, such as, we have brought cases that have involved Title VII, but in addition, they involve claims for negligent retention or negligent hiring. We might have an assault or a battery claim. So when we are handling these cases, we are looking at what's available under the federal law, but we certainly are also looking at what state remedies might be available to them, and torts are certainly remedies, certainly types of claims that we would bring in our lawsuits. The other thing I think that is unique to immigrant victims of sexual violence is that some of these women who are experiencing sexual assault and rape, who are undocumented, are eligible for something called the U visa, which is an immigration visa available to people who are victims of certain types of crime. So in certain instances, while we bring litigation on behalf of victims under Title VII and or under state laws, we might also seek relief for them, under immigration relief for them, by way of a U visa, or in some cases, the T visa, which is the visa given to victims of human trafficking. So with domestic workers, we certainly would look at the full range of civil remedies available to them. We would help them in our practice, because we believe in a holistic model of representation. We also help people navigate the criminal process where they want to file a police report against the perpetrator. We'd help them with that. And then where there might be any other kinds of relief, like victims' compensation or immigration relief, we would help them with that as well.
Cindy, did you have a question? Did you?
No.
Oh. Yeah, in the back right there. Yeah.
I'm Paul Ramshaw with the EEOC. What percent, if any, of the immigrant farm workers are unionized, and what role is the union taking?
So farm workers are exempt from the National Labor Relations Act. There are membership, of course, in California, we have the United Farm Workers, and that is by way of state law that they're able to unionize. There are farm worker membership organizations in different parts of the country. There's one in Florida, there's one in New Jersey, one in Ohio, in North Carolina, and Oregon. So there are states where workers are organizing, but for the most part, the workers are not organized, and they don't have the benefit of a collective voice of bringing forward these issues. And what I found in talking to people who, membership organizations and people who are involved in union organizing, is that one of the difficulties with these cases is that, when farm worker cases are being litigated, typically because the resources are pretty limited for a legal services organization who handles farm worker cases, the choice that has to be made is, how are we going to get the largest number of people relief? And a lot of these sexual harassment cases, while there might be more than one woman who's experienced sexual harassment, there might only be one who will come forward, and maybe for whatever reason, this isn't a case that could be classed, or there isn't going to be Title VII. The EEOC is not going to try to litigate it as an EEOC class. And so then you have organizations that are having to make a decision about whether or not, given the limited resources, these kinds of cases are cases that they would litigate. For the union, one of the obstacles that they've talked to me about is that where there is union organizing going, a certain kind of campaign happening, and the co-workers are the sexual harassers, then they feel like they have a conflict, because then it would be one worker against another worker who they're trying to organize. And so there's been, I think, a little bit of tension related to how to deal with that issue. And I know that one of the other panelists is going to speak to unionizing efforts, but in my discussions with folks who are involved with farm worker membership organizations and unions, I know that this is something that they've come up against.
Yeah, right down here. And I think this will probably be the last question, Monica, unless you have more time.
Thank you. I'm Dave Rabinowitz, and I was wondering, you mentioned that in your surveys you got 90 to 100% of women who reported harassment. I'm wondering if you have some idea of what percentage of the men are involved or actually harassers. Is it a small percentage where you need individual correction, or is it a large percentage where you need cultural change?
That's a great and hard question. I think a little bit of both. The women that we interviewed didn't talk about one particular work site. We did not, and I'm speaking to the Injustice on Our Plate survey that we did. So we did not ask them to name every employer that they had worked with and whether or not they had experienced sexual harassment, with each given employer. But what we gathered in doing our surveys was that the women had experienced the harassment from different places by people in different levels within the company. So there were company owners who were sexually harassing, and supervisors, and then coworkers, and sometimes third parties. I mean, we're hearing a lot about the DSK case right now, and the Sofitel case, which would be, if you look at that sort of from the lens of an employment case, that would, for all intents and purposes, be a situation where it's a third party harassment case, potentially. I'm not suggesting that one is, but when we look at situations like that, we would look at them as customers or agents who are involved in discrimination and harassment. So in any case, I think that it's safe to say that there are workplaces where it's one person who's committing harassment, and that one person is harassing, a few people, or, a particular, just their work crew. But we've also seen situations where the workers are there's one main supervisor who is then sort of deputizing underlings to help pick the women who are going to be sexually harassed. And so they're actually, I worked on a case in Florida where the supervisor actually would tell other supervisors which women off of the crew he wanted to be made available. And then in those sorts of situations where it's so widespread, then you have coworkers who are also engaging in the harassment. So you have the sexual harassers who are the owners and supervisors who are creating an environment where other workers feel like they can harass. So I think that we have, in the cases that we've looked at and or worked on, you have some situations where it's one person who's the problem, or a few people who are the problem. In other cases, it's widespread, and it's many people at the work site, and it's in different levels of in the employment setting. And then in terms of, is it a cultural shift? Yeah, I think that there's, not just within the immigrant community, I think a cultural shift has to be made across the board, because when I talk about sexual harassment with people outside of my position as an employer, people joke about sexual harassment. They laugh about sexual harassment. You look at shows on TV and there are jokes about sexual harassment training, or there's, when we talk about whether or not a man can be sexually harassed, for example, people think that's very, it's funny. How's that possible? And I think that as a culture, we don't talk about sexual harassment as something that is grave and dangerous and debilitating. And I think as a culture, as people, we need to change the way we talk about sexual harassment. I think that in the immigrant populations where I have worked, there's been a lot of discussion by the women who I've represented about machismo and about feeling like this is the way things are and this is the type of behavior they have to put up with. There's one woman who I represented who said, when I grew up at home, I was my father's property. When I got married, I became my husband's property. When I went to work, I became my boss's property. But I don't think that the women that we represent are alone in feeling like they have to follow certain social norms. I don't think that just immigrant women in this country feel the shame and the pressure related to being harassed and then not wanting to report. I think that there are women immigrant women and non-immigrant women in many sectors of our employment, of our workforce, who are being sexually harassed, and men and children who are being sexually harassed. But I think that because sexual harassment is not talked about as a form of sexual violence, and we aren't talking about it as something that's dangerous and debilitating and extremely harmful to the victim, I think that that is why people laugh it off. And I think until we change that, and until the media changes that, I think that sexual harassment is going to continue to be a workplace problem for immigrant women and for others.
Okay, thank you so much for being with us, Monica. This has really been very, very informative and helpful.
Thank you so much.
You're welcome to stay with us if you can, but I know you have lots of other things to do. Okay, if our panelists for the second panel can come forward and the rest of this panel can step down, that would be great. Yeah, so Carol, I think you're going to be, yeah, no, Carol's going to be second, so Jennifer, yes, so Carol's, yes, Jennifer's there, yeah, okay. Choose some fresh water glasses. Okay, while we're getting the water and everything lined up here, let me just quickly introduce our next two panelists on this panel, which is going to deal with the issue of the way forward, although I'm sure we'll also have some reflections on where we are now. Our first speaker is going to be Carol Rosenblatt from the Coalition of Labor Union Women. Carol has been executive director of CLU since April of 2000, and she was active in founding the organization in 1974. So again, we're going back to that very rich period, creative period of feminist ferment, and seeing how long these organizations have been in place and how much work they've done and still how much there is to be done. And then our second speaker will be Jennifer Goldstein, who is a senior attorney at the appellate division of the EEOC, and will be able to tell us something about what's going on now in terms of these cases. And she has argued over 45 cases in the U.S. Court of Appeals and elsewhere on behalf of EEOC. So 2 more panelists and lots more information. Carol, the floor is yours.
Thank you. Well, what a presentation to follow. And the whole earlier presentations have been fascinating. So I'm very pleased to be here on behalf of the Coalition of Labor Union Women, and particularly celebrating 25 years today of the Meritor Savings Bank versus Vincent, which is great. And we were part of pursuing justice on behalf of the plaintiff at that time, and are very pleased that that happened as well. So sexual harassment has been very important to our organization. We educate our members, and then we urge them to educate the larger labor movement. Obviously, there's been some discussion about the roles unions have played, and what we hope to do in terms of today, certainly nothing as involved as the data gathering that has been discussed earlier, but we did realize that in trying to get together information for today's presentation, there's no central repository of this in terms of unions. So in a month's time, and with an intern's help, we kind of developed our own survey, and we interviewed union officers and officials of CLU, and did some online resource gathering, and we by no means mean to make this a comprehensive analysis, but kind of a snapshot of what some of the policies are in place in terms of sexual harassment and what workers to some extent are still dealing with at work. So in March of 2009, the AFL-CIO, through its Executive Council, issued a statement on the charter rights of working women, which stated in part and I quote, "The AFL-CIO will do all in its power to secure for women the rights set down in this charter." And one of the provisions under access to employment and promotion is, and I quote, "Employers must be held responsible for ensuring that women have a safe workplace free of all forms of violence and sexual harassment," end of quote. And in closing, it calls on its affiliated organizations and other progressive forces to commit themselves to the promotion and implementation of the principles set out in this charter. Now, the AFL-CIO can urge, but they can't force unions to do things. So, this set a goal, and one that, we looked at in terms of, now, what are the unions doing? So we looked at whether unions have policies in place, and yes, they pretty much do have sexual harassment policies in place organizationally, and they have a variety of different kinds of educational tools in place at various levels, from stewards, which I think does anyone here not know what that term means? If so, I'll explain it. Otherwise, I'll just assume that you do. It's kind of the representative in the workshop floor up through the various leadership levels through in the union. And so we're going to take some unions and give you some examples. And I won't do it all by acronym because I won't expect you to know what they all are. But in terms of AFSCME, which is the American Federation of State, County, and Municipal Employees, they have, various online tools, one of which is a statement, which of course I think we all acknowledge, sexual harassment, it's about power. And in that section, they say what to do if you're sexually harassed on the job. So this is directed to a member or a worker. Very basic. Don't think it's your fault. Seek support from family and friends. Object. Speak to the harasser and be specific about what behavior you find unwelcome. Keep a log. Speak to your union steward. Speak to your supervisor. If these steps don't solve the problem, file a formal complaint with your state human rights agency or the EOC. Pretty simplistic, but, nevertheless good information. UE, which is the United Electrical, Radio, and Machine Workers of America, also have information for workers, and this is directed to stewards on strategies for stewards in fighting back. And they indicate that every instance of sexual harassment will be unique, and creating appropriate responses will require the steward to be thoughtful, sensitive, and resourceful. So some of the suggestions they offer are that the union should make all members aware that sexual harassment is illegal, and the union will fight on behalf of its members to stop it. Make the employer post notices that say that sexual harassment is illegal. That many women are not sure who to turn to when they are being harassed, so the union can appoint several stewards who are respected, and of whom at least some of them are women, that can be a special committee to deal with sexual harassment. When dealing with the issue in grievance meetings, make sure the women are not going through yet another harassment session. So they should not have to recount the experiences that they've encountered through harassment by having to expose all this through a whole group of many bosses. So force the company to show some sensitivity. And then make the harasser pay for the crime, not the victim. Too many times, the victim is forced to say, move from her job, rather than the perpetrator to move from his. Ray Bradford, who's the national director of the American Federation of Television and Radio Artists, said that they have, the Equal Employment Opportunities Department, said their members are somewhat challenged in that many of them do not have steady jobs. So they feel threatened and fearful about reporting harassment for fear of retaliation up to and including termination. So education is particularly important, and of course media is something that they promote. So they think that in addition to traditional training, that also going on labor radio, using Facebook, Twitter will encourage you to expose the issues to a larger audience and a younger audience. And of course, the casting couch is still alive and well in Hollywood. There's been any number of kind of recent exposés on this. Gwyneth Paltrow spoke about it, Megan Fox, Lisa Rinna, and others have talked about it and what their experiences have been like. One of our vice presidents, Janet Hill from the United Steelworkers, mentioned that sexual harassment in her union is administered from the Civil Rights Department, who have developed civil rights guidelines to provide guidance for union members and leaders to help eradicate discrimination in the workplace. And they've designed kind of a pocket guide for civil rights committees, which are supposed to be established at every local union, to explain how a member deals with civil rights issues. And they've established a committee on sexual harassment specifically to deal with that investigates complaints and develops educational programs for employees of the union. Connie Cordovilla, the Assistant Director of Human Rights at the American Federation of Teachers, said the union urges its locals to pursue contract language which protects members of the bargaining units from sexual harassment, citing it as a form of discrimination, and encourages and supports programs to further understand and combat sexual harassment. She also said that schools are not required by law to provide sexual harassment training, but school districts that are found to have incidents of sexual harassment are viewed more harshly by courts than those who have extensive staff and student training. Carolyn Williams, our Director of Human Services in the International Brotherhood of Electrical Workers, informs us that in addition to training that is provided for business agents and stewards, a women's conference takes place every 2 years that is attended largely by rank and file members, and workshops on sexual harassment take place there. They also provide suggested contract language on sexual harassment that they urge their locals to adopt. Sandra Burleson of the Transport Workers Union expressed that transit companies should train employees on sexual harassment the same way they train on issues of security. Public transit needs to be made safer. She went on to state that public workers are in an especially sensitive situation and need to be educated on how to respond. She gave an example that is not atypical of a female bus driver that has to deal with a passenger that flashes or touches her. They need to know what steps to take, yet reporting on a customer still has to be done with care. The growing numbers of women in leadership in the union has helped as women members who experience sexual harassment find it easier to raise these issues with someone of the same gender. Georgie Ann Bergamian, okay, I should be able to get there, of the United Auto Workers informs us that the international union demands that broad anti-discrimination language is included in all contracts and sexual harassment policies are established by a special bargaining convention that occurs every year. We also spoke to Casey Wagner, the Director of Workplace Studies of Cornell University, asking her to reflect on changes over the last 25 years. And she stated that there is an institutional recognition on both the part of employers and unions that sexual harassment is an issue that has to be dealt with and addressed. Employers usually have a sexual harassment policy, and some level of training of employees takes place. And unions, there is more emphasis on training stewards. However, while responses may have changed, one thing has remained constant: that sexual harassment is part of a continuum of violence towards women. So in ending, it would be naive if I said, and obviously some of the other presenters indicated that, not all workers feel comfortable reporting sexual harassment or even know where to go, and not all stewards know how to identify it or how to advise and encourage workers to take action. So, clue, we'll continue to educate, we'll continue to raise the issue, we'll continue to push and push until the labor movement and the rest of society combats this most vigilant, most ugly form of discrimination.
Thank you very much, Carol.
That's okay. I want to give you a little bit of background about EEOC, how EEOC gets involved in cases, because I'm going to be talking about some cases in which I've been involved. We bring cases on behalf of individuals. We also get involved in the courts of appeals as amicus. So with that, as everyone has mentioned, it's been 25 years since Meritor savings, but there are still a number of interesting legal issues that exist still, and I want to talk about two of them that have been coming up a lot in the last 5 years in particular. The first has to do with the because of sex part of Title VII, which prohibits discrimination because of sex. This was touched on, and I think in the first presentation. The second issue I want to talk about is that courts seem to have problems dealing with sexual harassment issues when you're talking about employees in remote locations. Just as background on the first, I know there was some mention of the Oncology decision. Courts had been having an awful lot of difficulty figuring out how to deal with because of sex, what that meant when the harasser and the victim were of the same sex. They just found it perplexing. In the Oncology case, which was a case involving a man who worked on an oil rig in the Gulf of Mexico and was subjected to awful harassment by his male coworkers, the Supreme Court, we thought, cleared up a lot of the existing issues. Rejected the categorical rule. The critical issue is, are members of one sex exposed to problems that the other sex isn't exposed to? You can look at, it doesn't have to be motivated by sexual desire, which was what a lot of courts had held. And you can just compare how the harasser treats men and women to prove because of sex. Since Oncology, though, courts have been very confused in two different sort of flip side scenarios. What if it's directed at women but not sexual? And conversely, what if it's sexual or gender-based but not directed? So the first case I want to talk about actually is a rare case against a union. We actually don't see very many. But this was a case against the NEA in Alaska where the head of the office in Anchorage was repeatedly screamed at he didn't do this to the men, but he would scream at the female employees. He would get right up into their face, and he would be so enraged that spit would fly out of his mouth, and he would bang the table. And the women said that they were afraid, and in fact, they actually ended up handing out whistles to everyone in the office so that if he came up to them, they could blow the whistle and everybody else would run up. He didn't, it was a little bizarre, actually. He didn't do that to the men, but the district court granted summary judgment to the employer, saying, well, he wasn't motivated by lust, and he obviously wasn't trying to get women out of the workplace because the NEA actually had majority women. So you can't show, EEOC you didn't show because of sex. We appealed, the Ninth Circuit reversed, I think reiterating some of the points the Supreme Court had thought it made when it issued its decision in the Oncology case. It doesn't have to be motivated by lust or desire to drive women out. And a lot of times, and I think there have been a lot of scholarly articles on that bullies will take advantage of whomever they perceive as most vulnerable. In this particular case, I think he perceived the women were vulnerable. And that is because of sex. Now, the flip side of this, and excuse I didn't want to have to say the words, so I put them up on the PowerPoint, is when it's not directed at women, but obviously has a gender-related or sexual content. And actually, I think you mentioned the Harris case in the Fourth Circuit. This was another case that I happen to be involved in, or EEOC got involved in as amicus. This involved a woman, Ingrid Reeves, who came into the workplace she was the only woman in the sales department, and it had been all male. I should say she had been to the U.S. Merchant Marine Academy and had worked on ships, so she was not a woman of Victorian sensibilities, as Judge Posner would put it. She was a tough woman, but this was, the words that you see on the screen are what she heard on a daily basis. The first, you see the coworkers would refer to customers or women in other parts of the office this way. And even the branch manager who sat fairly close to her, that was how you can see the words that he used to talk about women. She filed suit. Again, the district court ruled for the employer. It wasn't motivated by her sex because it wasn't directed at her, and everybody heard these words. So it's not discrimination because of sex. It actually, it was appealed. It went to the panel on the 11th Circuit, which is located down in Atlanta, and then the full court heard it. And they unanimously, which is sort of a shocking fact because they're not a particularly liberal-minded court, but unanimously held that this was because of sex. That this is some of the comments from the part of the opinion rather. That if you hear these words, it doesn't matter if it's directed at you or not. That this is going to change your environment. They also, it's a fairly interesting opinion that the employer, among other things, had argued that because sometimes the men, when they would say bitch or whore, were actually referring to men, that therefore there wasn't a gender component to it. The court rejected that. As you can see, it obviously was meant to denigrate men by calling them bitch, which is a female, generally refers to a woman. So that was really a great victory, and especially in a unanimous opinion. And now there have been, these cases have come up in a number of different courts, the Fourth Circuit, the Second Circuit, and actually courts have been fairly good at the Court of Appeals level of recognizing that this can be sex discrimination. The second category of cases that I want to talk about, or where legal issues have come up that are fairly interesting, has to do with scenarios that are involved in remote locations. And I have to say, every time I see this, I think about my kids. And I know that if they saw this, they would think I was talking about them. But the teenager problem actually is not, I'm not actually referring to my kids. Teenagers we see working in places like Burger King. And they are, I guess because they are considered very vulnerable, have been subjected to harassment, we think to a fairly large degree. This particular case, this V&J case, this was a company that owned a number of different franchises. So each franchise was sort of its own little island, and then the headquarters was somewhere else. The teenager in this case was a 16-year-old who got her 10-minute orientation and handed a booklet that she promptly lost, and then went to go work at a store where a 35-year-old was the general manager. He began harassing her, beginning with sort of sexually suggestive comments, and then leading up to offers to pay her money if she would go to a hotel with him. She had a hard time complaining. She actually tried. She asked shift supervisors, should this be going on? And they said, oh, just deal with it, just go with it, just push them off or something. She asked the assistant manager if there was some phone number he could give her so that she could call, and he said that he didn't think he was supposed to do that. She just didn't know how to complain. The district court said, your complaint didn't reach the employer, so they can't be liable. They had a policy, and there was some information in an orientation handbook, and so because they didn't get notice of the harassment, they can't be liable. Again, we appealed, and the Seventh Circuit reversed. Judge Posner, who I actually was great on this. He pointed out that your complaint mechanism, it has to be a real, meaningful complaint mechanism. He actually said, he pointed out if all your employees don't speak English and your harassment policy is written only in English, that's not going to be reasonable. And here too, where you have a teenager, you've got to make sure that the complaint mechanism is suited for a teenager who's not going to, this was in fact this girl's first job, and it's likely that when you're talking about teenagers that they don't have much experience, they don't know what to do, they don't know that they can figure out where the corporate headquarters is. There was nothing on the wall. And Judge Posner said, you've got to make sure that your policy is adapted to your workforce. So that was, again, a case where the employer and the lower courts had not been very good, and then the Court of Appeals got it right. The last issue and the last case I want to talk about is actually the truck driver problem. This is actually a case that's currently in the Eighth Circuit. They haven't oral argument. There's been oral argument, but the court hasn't ruled. It's a case involving CRST, and CRST is a it's a truck, it's got a particular business model, which is that they do long distance fast hauling. And to do it fast, they work in teams. And as you can see, the cab is fairly large, so one person might sleep while the other's driving. Problems arose when males and females were partnered together. In this case, a charge was filed by a woman who alleged sexual harassment. EEOC started investigating, and we thought we might uncover more women who might have been subjected to sexual harassment. The numbers kept growing. It went well over 100. And the harassment that they reported ranged from comments to men urinating in a cup next to them, to masturbating next to them, to sexual propositions, to a number of cases of rape and sexual assault. The district court had a lot of problems with our case. And actually, what's interesting about this is not only did the court rule against us, but it awarded, I can't remember how many millions of dollars in fees against the EEOC, which is only permissible if our action is considered to be frivolous and unreasonable or without foundation. There's some interesting procedural issues that also underlay the judge's order, but I think this is an interesting case to watch because we're hopeful that the Eighth Circuit will reverse. But among the things that the court has held were that in a lot of these scenarios, the women were actually being trained by men, and the liability, to establish liability, it's a little easier if the supervisor is harassing than a coworker. The district court said that those people are not, even though they're isolated, they set your schedule, they tell you when you're going to sleep, when you're going to eat, when you're going to go to the bathroom. They're not supervisors. The court said, well, yeah, there wasn't that much anti-harassment training, but it's really hard because these guys are truck drivers and they're not really on site ever. So it was, understandable that they didn't have that much training. The district court said that in a lot of these cases, the employer didn't have notice of the harassment because, they would call, but they would call after the fact, and then usually, not always, but usually, eventually they could get the women off the truck or something like that. Of course, there was a problem in that a lot of these women couldn't use the phone mechanism on the truck because her partner was right, her coworker was right there. CRST they never found that harassment had actually occurred, no matter what the evidence was. And they said, well, it's just a he said, she said, so it's sort of understandable that they didn't make any findings. The one thing they would do, though, is they would occasionally warn them, and they would say, okay, no females for 6 months. You have to go without a female in your truck. You can't have a female partner for 6 months. That was considered to be the remedy that was considered appropriate. The HR department was 2 people. They made a big chart that showed, look, we're keeping track. This is how many, it was huge, how many harassment cases we have. And they thought that one actually was fairly, showed that things were going well. So there are a number of arguments we're making, but the 3 main ones are, we are arguing that they're supervisors, that, these guys are the kings of this little work environment. And they control enough that, yes, they can't hire and fire, but they can make recommendations, and they control every aspect of these women's work life, so that they should be considered supervisors. We're arguing that they had constructive notice, that when you've got a chart, you've got a problem, and just because you might not know that truck driver, Joe might not, you don't know that he's going to harass Jane, you know that this is a problem. And the third argument that we're making is no females is not discipline, that these women are very vulnerable. They're in trucks, they're isolated. In that scenario, the remedy has to be, your policy, just as Judge Posner said with regard to teenagers, where you've got women in isolated environments, you may need to be more vigilant. And among the things you may need to do is actually fire somebody or really discipline them for harassment. It's just because somebody denies it. If you talk to HR people, they say you can't just take a denial and stop there. You've got to talk to them. And that's not an excuse to say he said, she said, not to try to figure out what's actually going on. That's it.
Thank you very much. I think in the interest of time, we're really sort of out of time, but I hope that you'll all be willing to stay for a few minutes longer for some Q&A, and then we'll get to our reception. So if the other panelists can come back up, and then we'll just ask if you could direct your questions to any or all of the panelists. I know there are probably a number of questions and comments from all of these very rich presentations. And please wait for the mic and identify yourself if you have a question or comment. Yes, right here. Or maybe it's a better, I think, oh, all right. It's usually better to go around.
My name's Serena Thornton. I'm a professor at Hampton-Sydney College. I have a question for Ms. Goldstein, and it's related to the last case you talked about. I've seen on a number of college campuses situations where harassment is going on, but they don't know exactly who the perpetrators are.
Well, they've got to, I mean, they have to, the statute requires them to take corrective action, and obviously it's always going to depend upon the circumstances. You know, I think the employer is obliged to do a full investigation. In some circumstances, you're going to have repeat harassers. And then if they truly can't figure it out, they need to do something to ensure, I mean, especially if it's a repeated problem, to ensure that people are protected from however they do it. And in some way, the district court actually in the truck driver case was critical of the EEOC for not coming up with all sorts of ways that telling them what they should have done. And I'm a little reluctant to say, because each case, of course, is going to be different, and each HR department or investigator is going to have to figure out what's going to be effective. And I think what we said was that they just, in that particular case, they had washed their hands of it and said, we can't do anything, and that's never the case. There's always something, and it's a little hard for me to say in the abstract what would be best, but the employer is obliged to protect you, to make sure that you work in an environment that's free of harassment, and that's going to mean punishing people who harass at times. You know, obviously there's a flip side that I think employers get nervous about being sued by people wrongfully alleged to be harassers, and I think they get nervous and they try to walk a fine line, but which is, it's not invalid, obviously, but
I was just going to add that, so for colleges and universities, they also have independent obligations under Title IX as recipients of federal financial assistance. And, you know, I think what my ears perked up when you said sort of repeatedly happen, you know, that's the type of thing if there was an investigation by the Office for Civil Rights or that they really look at how they have addressed conduct that happens repeatedly on campus, and is it just one incident, is it campus-wide? So
Don, yeah, right here. Yeah.
Hi, I'm Don Wolfensberger with the Wilson Center. I'm not a lawyer, so I'm curious about two aspects of the consent decrees. One is, are these always worked out voluntarily between the parties and their lawyers, or does the court get involved in some way in arbitrating these? And then secondly, does the court have to pass on whether the final consent decree is fair, or is it just the parties themselves that agree? And then the other part is, with the three major cases mentioned, having the follow-up monitors. I used to work for Lynn Martin, who was a congresswoman and then Secretary of Labor, but I think she was one of the monitors on the Mitsubishi case, as I recall. But how long do the monitors stay on in those cases, and then is there any follow-up after if they are discontinued, is there any follow-up to see whether the company is still abiding by those agreements?
So the consent decrees, the ones that are public, done by the EEOC or the Department of Justice for public employers, or in class action cases, that they're negotiated by the parties, but they also are then go through the court and are approved by the court and sort of court enforced. And if the parties can't agree, then they end up going to trial. So it's sort of both of those things. And when there are monitors, they're usually for the duration of the decree, and for the cases we looked at, most of the decrees were like around 2 or 3 years. And Lynn Martin, I believe she was brought in by Mitsubishi to sort of turn things around internally, as opposed to being a monitor. In Dial and Mitsubishi, the EOC used this system of having 3 monitors, one nominated by each side and one by the court. And I think she was the sort of the person they brought in. She was separate from that.
Yeah, I wanted to answer that. And when we talk to people negotiating those, they said often the judges did have an influence, for example, on the type of remedies the EOC could put through. And what struck me in some of the cases you mentioned, Jennifer, is that, you think, how can these district judges rule like that? Where do they live? And you think, okay, I'm not a lawyer, and maybe it's in the law, but I think some of this is often that there seems to be a mindset, okay, there's enough regulation already, and we need to protect employers to do their business, and employers know best, and that the EOC sometimes finds it hard to get through the kind of measures I mentioned, which to me seem, coming from a human resource management best practice perspective, seem to make a lot of sense, that you have transparency and some accountability. Every management textbook on anything tells you the first thing is, what you want to do, and then you measure and you have accountability. And that they cannot get through basic kind of rules around that basic issue, supervisory accountability, because some judges feel that's an imposition on employers. So I do think the role of judges, which is why I want to comment, is pretty crucial, and where judges get their experience and their education. And I think one of the issues some people have mentioned also, that in the district judge courts, it isn't very often that you get something that involves injunctive relief or policies aimed at dealing with employers' practices. So they don't have a lot of experience in that. But in any case, I think judges somehow are also a target for education or discussion on these issues.
Yes, a flip right here. Yeah.
Philippa Strum from the Wilson Center. Thank you all so much. This has really been a fabulous, fabulous panel. My question is, Ariane, you mentioned a couple of cases with farm workers that were obviously very successful. And Monica gave us information about how terrible the situation is there. And I'm wondering, to what extent are cases brought in one part of the economy used for educational purposes in that part of the economy? I mean, for example, to what extent are the cases that you mentioned publicized throughout the agricultural community? Is this a possible way of dealing with the situation in a very small sense? Is this done at all? Thank you.
And Jennifer might also have to add to that. The EOC makes a lot of efforts to try and get the information out in some way or other. They always issue a press release, and that the kind of consultants who work on employment law management side, lawyers, monitor those and also get out that information. Although we also know that sometimes employers are really pushing back on that kind of ability to do press releases or get the information out. In the farm workers, as I said, there were 300 consent decrees annually in the whole country. I don't know, on Esperanza or on Monica's website is a list of all the cases that involve farm workers, but it isn't that many, and there are many more people working there than will ever be touched by a lawsuit. So the challenge there is what we found in the organization that was subject to a lawsuit. You kind of think, the lawsuit tends to stop harassment, and maybe beyond the consent decree for 2 to 3 years, but then you almost have to start again, because particularly in the farm industry, it's new workers, and it's new supervisors, new conditions, probably also the people, even, and the advice centers might have changed. So you have to reinvent the wheel or constantly monitor in those cases. But I do think, communication around that is really very important. And, we probably need more, but the EOC, I think, trying to use that as a tool.
If I can just add something on that. There's like other research that has looked at what, when there are widespread or well-known lawsuits, discrimination lawsuits in an industry, do then other employers in that industry sort of shape up? Are there more women and minorities in management is one of the key ways they have looked at it, using large-scale EEOC data that where employers report statistics. And there's some indication, like in the supermarket industry, that it has some impact, though it's kind of mixed. And the other thing that we found in some of our interviews was that in some cases when there have been other consent decrees in an industry, somebody being sued and, let's say, working on a consent decree, they'll look and see, well, what did these other people do? Or they will, before agreeing to do something, say, well, want to know, are there any other employers in our industry who do that? So and then there's a whole line of research that shows that organizations often look to like leaders or others in their field to see kind of what kind of practices they want to adapt. So there can be an influence that way. But on the other side, one of the chapters in our report that Evelyn Murphy worked on it was a case against the American Express Financial Services. And, there have been this whole history of cases in the financial services industry and on Wall Street, one worse than the other, and it seems that those people never learn. And in some cases, I think it's this thing that, like, if there's enough, the costs of what they pay out doesn't compare to what they think they can, get, and earn in their business, and, so anyway, so that's a kind of mixed response to that issue.
Jennifer, did you want to add to that?
Well, I was just going to say, EEOC, to a large extent, I think we do have the way we decide to bring cases is kind of diffuse. The regional attorneys who are all over the country, for the most part, have the authority to make that decision. And to a large extent, although on the one hand, I think they have goals, and I know in Northern California they have been focused on some of the kinds of cases that have been discussed. It sort of depends on who comes to them. So we are always concerned about retaliation issues, because the only way we can move forward is if people don't feel afraid to come to us and file a charge of discrimination. So the cases that we bring, in some senses, are happenstance, who comes to us. In some senses, it's more thought out.
If I could sort of follow up with that, I had a question for Carol. I think you said it was AFSCME that suggested that the people who have felt themselves to be victims of sexual harassment sort of take the initiative to confront their immediate supervisor, I guess, and to go sort of up the chain of command. And I'm wondering how effective that is, and whether or not that doesn't make someone very vulnerable to retaliation.
Well, I think that I suppose it depends on exactly what they're experiencing, but there have been cases where people will say, well, you haven't notified the person to stop, for example. So I think that would be comparable to someone saying, this is behavior that's intolerable and you have to stop it. So that is still something that they recommend.
Is that part of the law? Jennifer, does the victim have to take that initiative first? Is that to say stop it?
Well, they have to. It has to be unwelcome, and depending, if somebody rapes you, I don't think you have to say. I mean, so it depends on the circumstances. In other words, sometimes problems arise where there are a lot of jokes, and you kind of laugh along, but really you're not comfortable with it, then, there might be more obligation to kind of convey that this is unwelcome. So it really depends.
But it puts a lot of onus on the person, especially if they're isolated. It must be difficult. Yeah. Did you have back there, yeah.
Hi, yeah, my name is Sally Greenberg. I'm with National Consumers League. I wanted to clarify that point you made. It occurs to me in law, if you're working for a company and you're driving, you get in an accident, your employer is deemed to be responsible whether you tell them or not. So you don't get the same benefit in the sexual harassment context, I guess is what you're saying. By the way, I agree with Flip, who said this was a fabulous panel. It's really fascinating. I've learned a lot. I'm going to ask a question, and Sonia will tell me if I'm not allowed to ask this, but can panel members comment on the Strauss-Kahn case and the impact that it had on sexual harassment cases and the public's perception of sexual harassment? I would really find that interesting, but if it's not appropriate for this panel,
I think if people want to
That's
comment,
okay.
they can. I don't know if anyone's actually looked at it systematically.
Well, the only thing I would say is it was interesting how after the Clarence Thomas hearings, whatever you thought of them, how if you look at our charge data, sexual harassment charges went from a very small number and they jumped tremendously. So I think if nothing else, and I think that's a function of the education, and people started thinking about it and talking about it and saying this is wrong. Now, I'm not sure how this will play out. I think on the one hand, for a long time, I thought, well, this is helpful that this is being talked about, and then now I'm not so sure. But
it may, but it depends on the disposition of the case. Yeah.
My first reaction would be that it's good that this is talked about. Now I'm nervous. I don't know.
I think it's interesting. In France, apparently, it's led to quite a steep increase in complaints. But if I think back of other high-profile cases which typically involve sports people, basketball players or whatever, and they often also in hotels in the service industry, I don't know whether that had an impact, because then there's always this issue, the kind of, can you get lots of money for they in harassment cases, they always attack the victims, or very often. So but I felt, well, at least it's back on the agenda, and this issue of, for example, harassment in the service industry, in hotels, people cleaning rooms, in the service sector, the cases we looked at in bars, where it's kind of seen as, well, you put women in danger almost, because customers expect it. You don't expect them to be physically attacked, but still the kind of sexuality is part of the job, and I don't think we kind of almost think, oh, well, that's done, and most people can take care of themselves. So I think it will be really interesting to see in 6 months or so whether it had an impact. It's a bit too early at this stage.
Hotel workers unionized generally?
There are certainly hotel workers that are unionized, and I think that this circumstance that they were, in fact, this hotel was organized. So perhaps she felt she could speak out when in other circumstances she would not have, and would have had no support. But, that's a pretty horrendous profession, generally speaking.
Well, I'm sure there are more questions and comments, and we can continue them over wine and cheese. So please join me in thanking our panel, and then join us outside for the receptionist.